Mr. Sergeant of Arms invites members into the chamber and closes doors. I hereby declare the House of Representatives of the 114th General Assembly of the State of Tennessee now in session. Will the members please stand? With the visitors in the gallery please stand and remain standing through the Pledge of Allegiance. Chairman Faison will serve as chaplain of the day. Chairman Faison.
Good morning, members. Thank you, Mr. Speaker. Members, a few years ago on a Sunday night, I was driving into Nashville and I was listening to the word on the way. And I'd made it into Ecclesiastes. And if you ever get in Ecclesiastes, it can get somewhat depressing. And for the first 5 chapters, everything is just really bad. And Solomon's made it big in life, but nothing's good for Solomon. And I was coming up the plateau, I'll never forget it. And it gets to this verse in chapter 5. And Solomon says, after he's just gone forever, about how bad life is, Solomon says, even so, I've noticed one thing that's good. And it startled me coming up. And I'm like, whoa, I've heard 5 chapters, everything's terrible. And Solomon's found one thing that's good. So now I'm focused in. And I want y'all to hear this morning. This is Solomon. Even so, I've noticed one thing that is good. It is good for people to eat and drink and enjoy their work under the sun during the short life God has given them, and to accept their lot in life. And it is a good thing to receive wealth from God and the good health to enjoy it, to enjoy your work and accept your lot in life. This indeed is a gift from God. God keeps such people so busy enjoying life that they take no time to brood over the past. As we're in here these last few days, I just want to encourage us, have some fun. Sometimes we get so busy, consumed with how we need to get this, we want this, but at the end of the day, we need to enjoy life. The thief comes to steal, kill, and destroy, but I have come that you might have life and have it more abundantly. Let's pray. Father, what a joy it is to be your child. What a joy it is to know that you love us the way you love us. Father, I'm grateful for everybody here that you have, before the foundation of the world were framed, chose to be a part of this deliberate body. I pray you bless them, encourage them, strengthen them, bless their relationships, build their relationships better. Allow us to be an example of your love to those around us. In Jesus' name, amen.
Chairman Faison will lead us in the Pledge of Allegiance.
Attention, salute, pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Mr. Clerk, please take the roll.
Roll call.
Mr. Clerk, please take the roll.
Mr. Speaker, 83 members present.
Let the journal reflect. No one's excused. Next order, Mr. Clerk.
Welcoming, honoring, and announcements.
Welcome, honoring, announcements. Representative Helton Haynes.
Thank you, Mr. Speaker. I would like to make welcome today former House member Patsy Hazelwood. She's here in the back of the room. Let's make her welcome.
Representative McCalman.
Thank you, Mr. Speaker. Good morning, members. And not to be humdrum, it is tax day, so yay. But beyond that, it is also Representative Aaron Mayberry's birthday. He looks pretty good for 73. But if y'all would just wish him a very happy birthday, we're proud you're here, brother.
Representative Pearson.
Thank you, Speaker, and members, if you all would please stand for just a moment of silence. Yesterday, a 17-year-old in our district, excuse me, if I could just get your attention just for one moment, a student in Millington Public Schools at Millington Central was shot and killed yesterday at Shelby Farms Park. And I spoke with the superintendent briefly yesterday, but the pain this family is experiencing and the loss for our community and the school is immeasurable. And for people who understand grief and loss, you know how hard this is going to be on a family to lose a 17-year-old to being shot and gun violence. And so I just ask that you pray for his family and continue to pray for the superintendent of the school and the students' peers as well. Thank you.
Thank you. Chairman Faison.
Thank you, Mr. Speaker. Members, I am fortunate to have the very best intern this year of everybody in Cordell Hull. No offense to yours. But this is little Ayana right here, and she's been working for me. Y'all make her feel welcome. Thank you.
Representative Slater.
Thank you, Mr. Speaker. And members, I think all of us appreciate our legislative assistants. I know that I do mine. And so today is a very special day for Chelsea. Today is her 25th birthday. So help me wish her a happy birthday.
Representative Moody.
Thank you, Mr. Speaker. Members, I think many of you have already been by to visit our desk. Excuse me, but I wanted to make sure you all knew that our Charms Factory in Covington, Tennessee is happy to provide these treats for us, and I'll have them here on the desk till we finish, and you're welcome to come by and enjoy. Thank you.
Representative McKenzie.
Thank you, Mr. Speaker. It sounds like it's a theme of birthdays today, so I'd like to wish a happy birthday to myself and Representative Johnson's intern, Erin Craven's in the gallery there. Let's wish her a happy birthday.
Representative Vital.
If you would please join me in a moment of silence. On Friday, a young sheriff's deputy by the name of Landon Faulkner was killed in a car accident on his way home in Hamilton County on the Sequatchie County line. 24 years old, a young family. And his father was a former member of this body by the name of Chad Faulkner, who served from 2008 to 2010. And we pray for this family and the pain they're going through right now. So for a moment of silence, thank you. Thank you.
Thank you. Representative Todd.
Thank you, Mr. Speaker. Members, I'd ask you to welcome a group from Union University in Jackson, Tennessee, the Turning Point USA folks. I have Riley Wynn, Summer Smith, Ella Martin, Evers Frank, Katie Halford, and Ariana Marlowe. Please welcome them to our chamber today.
Chairman Clemens.
Thank you, Mr. Speaker. Today I rise with Leader Love because the stadium is in his district to honor and recognize Nashville SC that won a big game last night. While the rest of us were sleeping, they were the first MLS team to ever win a competitive match at the famed Estadio Azteca in Mexico, and now they're moving on to the semifinals of the Champions Cup. So I want to give Nashville SC a round of applause.
Leader Camper.
Thank you, Mr. Speaker. Mr. Speaker, members, again, I rise to remind us that today our statement of interest is due. So if we didn't get it done yesterday, it's due today. Make sure that you file them with the Tennessee Ethics Commission. And if you have any questions, see Mr. Doug Himes. Raise your hand, Doug. All right, thank you, Mr. Speaker. Oh, we still got to pay taxes.
Representative Mayberry.
Thank you, Mr. Speaker, and thank you everyone for your birthday wishes. But one more birthday shout out is today Trooper Trent Hawkins' birthday. He is one of the state troopers that when you first come in off the main road on the ground level. So let's welcome him and wish him a happy birthday.
I believe that was everyone. Next order, Mr. Clerk.
Introduction of resolutions.
Leader Lambert, you're recognized.
Thank you, Mr. Speaker. That our resolution properly filed be introduced pursuant to order number 17 and placed on the consent calendar, referred to the appropriate standing committee.
Without objection, so ordered. Next order, Mr. Clerk.
Senate Joint Resolutions congratulatory and memorializing.
Leader Lambert, you're recognized.
Thank you, Mr. Speaker. That all Senate joint resolution congratulatory and memorializing on that has to be placed on the consent calendar, pursuant to order number 17.
Without objection, so ordered. Next order, Mr. Clerk.
Resolutions lying over.
Leader Lambert, you're recognized.
Thank you, Mr. Speaker. That all resolutions lying over be referred to the appropriate standing committee.
Without objection, so ordered. Next order, Mr. Clerk.
Introduction of bills, Senate bills on first consideration.
Leader Lambert, you're recognized.
Thank you, Mr. Speaker. The Senate bills 2,367, 2,450, 2,469, 2,473, 2,504, 2,537, 2,641, and 2,658 transmitted by the Senate be held on the desk pending third consideration of the companion House bills.
Without objection, so ordered. Next order, Mr. Clerk.
Senate bills on second consideration, House bills on second consideration.
Leader Lambert, you're recognized.
Thank you, Mr. Speaker. Move that House bills 2,667 and 2,668 be passed on second consideration and be held on the desk referred to the appropriate standing committee.
Without objection, so ordered. Next order, Mr. Clerk.
Petitions and memorials, reports of standing committees, reports of select committees, calendars. Mr. Speaker, the House has a consent calendar.
Chair Lady Moody, you're recognized.
Thank you, Mr. Speaker. I move passage of the consent calendar on third and final consideration in keeping with Rule 50.
Chair Lady Moody moves passage of the consent calendar. Property Secretary Mr. Clerk, any objections been filed?
Mr. Speaker, no objections filed.
Anyone seeking recognition on the consent calendar? Seeing none, we're voting on the consent calendar. All those in favor, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, please take the vote.
Ayes 99, nays 2 present, I voted.
Having received the constitutional majority, I declare the consent calendar passed without objection. The motion to reconsider is tabled. Next order, Mr. Clerk. Leader Lambert, you recognized.
Move to take up today's calendar, the calendar dated today.
Objection, so ordered. Mr. Clerk, call the first bill.
Mr. Speaker, item 1 on the calendar dated for today is Senate Joint Resolution 624 by Chairman Farmer, resolution proposing amendment to Article 4, Section 1 of the Constitution of Tennessee to specify that only citizens of the United States may vote in state, county, or municipal elections.
Chairman Farmer, you recognized.
Thank you, Mr. Speaker. I request the clerk read SCR 624 for its second reading.
Mr. Clerk.
Senate Joint Resolution 624 on its second reading, a resolution to propose an amendment to Article 4, Section 1 of the Constitution of Tennessee to specify that only citizens of the United States may vote in state, county, or municipal elections. Be it resolved by the Senate of the 114th General Assembly of the State of Tennessee, the House of Representatives concurring, that a majority of all the members of each House concurring, as shown by the yeas and nays entered on their journals, that it is proposed that Article 4, Section 1 of the Constitution of Tennessee is amended by deleting the section in its entirety and substituting instead the following. Every person being 18 years of age, being a citizen of the United States, being a resident of the state for a period of time as prescribed by the General Assembly, and being duly registered in the county of residence for a period of time prior to the day of any election as prescribed by the General Assembly, shall be entitled to vote in all federal, state, and local elections held in the county or district in which such person resides. All such requirements shall be equal and uniform across the state, and there shall be no other qualification attached to the right of suffrage. No person who is not a citizen of the United States shall be entitled to vote in any election held in this state, including elections for state, county, municipal, or district offices, or for any ballot measure, referendum, or other question submitted to the people. The General Assembly shall have the power to enact laws requiring voters to vote in the election precincts in which they may reside, and laws to secure the freedom of elections and the purity of the ballot box. All male citizens of this state shall be subject to the performance of military duty as may be prescribed by law. Be it further resolved that the foregoing amendment be referred to the 115th General Assembly and that this resolution proposing such amendment be published in accordance with Article 11, Section 3 of the Constitution of Tennessee by posting such amendment on the official website of the Secretary of State and on the official website of the General Assembly. Be it further resolved that the clerk of the Senate is directed to deliver a copy of this resolution to the Secretary of State, with this final resolving clause being deleted from such copies.
Chairman Farmer, you're recognized.
Thank you, Mr. Speaker. I move that Senate Joint Resolution 624 be set for its third and final reading on Thursday, April 16, 2026.
Without objection, so ordered. Next bill, Mr. Clerk.
Senate Joint Resolution 551, a resolution to propose an amendment to Article 7, Section 5 of the Constitution of Tennessee to change the date of elections for judicial and other civil officers.
Leader Lambert, you're recognized.
Thank you, Mr. Speaker. I request that the clerk read SJR 551 for its second reading.
Mr. Clerk, please read the resolution.
Senate Joint Resolution 551 for the second reading. A resolution to propose an amendment to Article 7, Section 5 of the Constitution of Tennessee to change the date of elections for judicial and other civil officers. Whereas Article 7, Section 5 requires elections for judicial and other civil officers to be held on the first Thursday in August, while Article 2, Section 7 requires elections for members of the General Assembly to be held on the first Tuesday after the first Monday in November. And whereas Article 3, Section 2 requires the election for governor to be held on the same day as for members of the General Assembly. And whereas Congress has also specified the first Tuesday after the first Monday for the election of United States senators and representatives and electors for president pursuant to 2 USCA Section 7 and 3 USCA Section 1 respectively. And whereas having all federal, state, and local elections on the same day would save this state and its local governments money and increase voter participation in local government elections. Now, therefore, be it resolved by the Senate of the 114th General Assembly of the state of Tennessee, the House of Representatives concurring, that a majority of all the members of each house concurring, as shown by the yeas and nays entered on their journals, that it is proposed that Article 7, Section 5 of the Constitution of Tennessee be amended by deleting the following language. Elections for judicial and other civil officers shall be held on the first Thursday in August 1870 and forever thereafter on the first Thursday in August next preceding the expiration of their respective terms of service. The term of each officer so elected shall be computed from the first day of September next succeeding his election, and substituting instead the following. Beginning with the election held in 2034, judicial officers and all other elected county officials, except the assessor of property, are elected on the first Tuesday after the first Monday in November, next preceding the expiration of their respective terms of service. The term of each officer so elected is computed from the first day of December next succeeding the officer's election. Beginning with the election held in 2032, the assessors of property are elected on the first Thursday in August, next preceding the expiration of their respective terms of service. The term of the assessor of property so elected is computed from the first day of September, next succeeding his election. Be it further resolved that the foregoing amendment be referred to the 115th General Assembly, and that this resolution proposing such amendment be published by the Secretary of State in accordance with Article 11, Section 3 of the Constitution of Tennessee by posting such amendment on the official website of the Secretary of State and on the official website of the General Assembly. Be it further resolved that the clerk of the Senate is directed to deliver copies of this resolution to the Secretary of State, with this final resolving clause being deleted from such copies.
Leader Lambert, you're recognized.
Thank you, Mr. Speaker. I move that SJR 551 be set for its third and final reading on Thursday, April the 16th, 2026.
Without objection, so ordered. Next bill, Mr. Clerk.
Mr. Speaker, that completes the calendar dated for today, Wednesday, April 15th.
Leader Lambert, you're recognized.
Well, Mr. Speaker, we finally completed one calendar. With that, I move that we go back to Monday's regular calendar.
Without objection, so ordered. Mr. Clerk, call up next bill.
Mr. Speaker, the House is ready to consider item 52 on that calendar. Item 52 House Bill 1823 by Representative Raper and others relative to attendance. Mr. Speaker, Senate bills on the desk.
Representative Raper, you are recognized.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 1968.
Representative Raper moves substitute form Senate Bill 1968, properly seconded without objection. So ordered. Representative Raper.
Thank you, Mr. Speaker. I move passage of Senate Bill 1968 on third and final consideration.
Representative Raper moves passage of Senate Bill 1968 on third and final consideration, properly seconded. Mr. Clerk, call for First Amendment.
House Education Committee Amendment number 1, same as Senate Amendment number 1.
Chairman White, you're recognized.
Thank you, Mr. Speaker. Move to withdraw and defer to the sponsor.
Without objection, Committee Amendment number 1 withdrawn. Next amendment, Mr. Clerk.
Amendment 2 by Representative Johnson. Mr. Speaker, it was timely filed.
Representative Johnson, you're recognized.
Thank you, Mr. Speaker. And of course, what this bill does is says that private schools will be under the same rule as the public schools that receive public tax dollars. And if a child leaves a private school to go to another school, regardless of what kind of school it is, they will be required to do the same thing. Because obviously, if we think this is important to do in our public schools, then our private schools that are getting public tax dollars should also be under the same rules. I think that what we're seeing here is a long line of hypocrisy when it comes to saying that we need things for a certain group of kids getting public tax dollars, then ignoring it when it comes to another group of students getting public tax dollars, especially now that it's going to be, about $300 million out of our budget. If you vote to do this because you think it's important for those schools, for those students going to public schools, then it really doesn't make sense if you don't think that those going to private schools with public tax dollars should be doing the same thing. So the reality is, if you think this is a good idea for some kids getting public tax dollars, it should be a good idea for every student getting public tax dollars. We should want to make sure that they also follow the rules that we think are so important. So I hope that you vote to support this amendment to show that you really do believe in this bill that you're voting for. I move adoption.
Representative Johnson moves adoption of amendment number 2. That's a proper motion, properly seconded. Any discussion on the bill? Leader Lambert, you're recognized.
Thank you, Mr. Speaker. Move previous question on the amendment.
Previous question been called. Any objection? Seeing none, we're voting on amendment number 2. All those in favor vote aye when the bell rings. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, please take the vote.
Ayes 24, 69 nays.
Amendment number 2 fails. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Representative Raper, you're recognized.
Thank you, Mr. Speaker. We have noticed a loophole in the truancy laws, and I'll explain what is going on. Currently, we have people that are getting to the truancy level, and this is tier level 3. That's the worst of the tier levels when it comes to truancy. And they're getting to that level, and then what they're doing is withdrawing, going to other schools, and if it's not in the same LEA, then what happens is it clears the slate. And then there are no consequences at that point. So we have many parents across the state of Tennessee that are doing this to avoid consequences for their child. Next thing is this. Currently, we have a situation such as, and I'm going to describe this to you. We have people that are transferring to non-public schools, and what happens is if they come back in a single year, then we are proposing in this bill to their record chase them, and then if they re-enter into a public school in that calendar year, then what happens is their record follows them. Also, if you have, and when I'm saying this, I'm saying a public school year, not a calendar year, but a public school year. Also, in addition to that, if you have someone that is going from an LEA to an LEA in the other part of the state, then also the record travels to them. At that point, I renew my motion.
Representative Raper renews the motion. Any discussion on the bill? Representative Halsey.
Thank you, Mr. Speaker. I just had one question. Does this bill affect homeschools at all?
Representative Raper.
Thank you for the question. It does not at all. In no way, form, or fashion, private, homeschool, anything like that.
All right. Representative Johnson.
Thank you, Mr. Speaker. My concern here, I appreciate what you're trying to do, because with the types of kids that I taught, I saw this a lot, and it can be a problem. But typically, we already did that. My concern is there are a lot of situations, because of the kids I taught, I had a lot of foster kids, foster students. And a lot of times they had not attended school when they were with their families. They get removed from the home and go into foster care. They need a fresh start. The reason they didn't get to school before was not because they were trying to be absent. It had to do with familial issues and all of that, no care in the home. So they get in the foster home. In addition to being in this new environment, then they're also going to be penalized at school. And I firmly believe that those kids need a fresh start. The same thing can happen in families just with divorce and things like that. Staying with one parent, and that parent, is the reason they don't get to school or don't get to school on time. Then they go to live with a different parent. I believe that kid should have a fresh start at that point. And so my concern is we were already doing this to a degree as far as I saw certainly in my county. But I'm afraid that it's going to put kids who need a fresh start and a second chance, who are going into a foster home or maybe living with a different parent, that's going to prevent them. Because no matter how much we want to think that a judge or a principal will have the concern for that kid, it just doesn't always happen in practice. So that's my concern.
Representative Raper.
Thank you for the concern. I also have concerns about going backward, about our truancy. And what you're talking about there is once they get to Tier 3, which this is what this bill is all about, it was amended for Tier 3 only, then they are now in the court system already, whether this takes place or not. So at that point, there's some point in time in our lives where we have to put faith in the judicial system. You may or may not, and that's not for me to say. But I think at some point that judges, no matter Democrat or Republican, that they look out for the best interest of people and also our children.
Representative Johnson.
Yes, this is certainly not partisan. And yes, I realize they're already in the court system, but I think that we need to take care of truancy, but I'm not sure where this was not being done already. We know that when we transfer records, that goes with them, and the school where they're enrolling is already going to get those records, and they're going to know. We always, in all our schools in Knox County, held those folks accountable when they came in. So I'm just not sure what we're doing here. And even though I appreciate the intent, I do struggle with some of the details, but thank you.
Representative Raper.
And one final comment I'll make is this. Where does this exist? In Bradley County and Cleveland, where we have all the time those transferring out of our schools. This actually was brought to me from our juvenile court judge, and this happens all the time. Then after the slate's cleared, they will come and transfer back to us, and once again they start over again in truancy, and it doesn't apply to whether it doesn't matter whether they go to a public or non-public school out of our district.
Representative Salinas.
Thank you, Mr. Speaker. My question is, I also have some concerns about this bill and its interpretation. How would truancy be interpreted, and would people be forced to turn people in if the student has not been attended as a result of ICE detention? My question has specific examples. This is not theoretical. Yasser Lopez Sosa has been missing from school for over a month. And Marvin Ponce Lopez has been missing school since November. So I think the students and the administration has had a hard time figuring out what to do in these cases regarding truancy. Are they considered truant? Would they be forced to be turned over to juvenile court when they were taken from their schools as a result of an ICE detention?
Representative Raper.
Would you mind just a little louder repeating your question, please?
Representative Salinas.
Yes, thank you. 2 students in Shelby County have been taken as a result of ICE detention. Are they truant? And how would your bill affect them and the administrators?
Representative Raper.
If they were truant before and declared by the juvenile judge, then yes, they're truant. But if that has not been declared by Tier 3 interventions by the state of Tennessee and by the juvenile judge, then no, they're not held accountable.
Representative Salinas.
So if they weren't truant before, this would not apply to them.
Representative Raper.
That is correct in the fact of if they were on the line, then at that point we have to decide where they are in truancy. If they are to that 5th one, then yes, the answer would be yes. But no, they're not held accountable if they are not to that 5th unexcused.
Representative Salinas.
Okay, I think it wasn't that clear, and it hasn't been clear to the administrators dealing with these cases. And this has been a problem that was caused by this administration, and I think clarity is necessary. So, yeah.
Representative Fritz.
Thank you, Mr. Speaker. Move previous question.
Previous question being called. Is there objection? Seeing none, we're voting. All those in favor of Senate Bill 1968 as amended, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, please take the vote.
Aye, 66, 24 nays, 5 present, not voting.
Senate Bill 1968 having received a constitutional majority, I hereby declare it passed without objection to most reconsidered table. Call the next bill, Mr. Clerk.
House Bill 2055 by Representative Reeves.
Representative Reeves, at your desk.
Thank you, Mr. Speaker. I move to refer HB 2055 back to calendar and rules.
Without objection, referred to calendar and rules. Next bill, Mr. Clerk.
Item 54, House Bill 2643 by Chair Lady Rudder, relative to the city of Winchester.
Chair Lady Rudder, you're recognized.
Thank you, Mr. Speaker. I move passage of HB 2643 on third and final consideration.
Chair Lady Rudder moves passage by second. Mr. Clerk, call it First Amendment.
House Private Acts Committee Amendment number 1.
Chairman Powers, you are recognized.
Thank you, Mr. Speaker. I move to adopt and defer to the sponsor for a further detailed, accurate explanation.
Chairman Powers moves adoption of committee amendment number 1. Probably seconded. Any discussion on the amendment? Seeing none. All those in favor of committee amendment number 1 say aye. Aye. All those opposed say no. The ayes have it. You adopted. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Chair Lady Rudder, you recognize.
Thank you, Mr. Speaker. House Bill 2643 would allow the city of Winchester to change their original 1953 charter to clarify language in the utilities portion of their charter. I renew my motion.
Chair Lady Rudder renews her motion. Any discussion on the bill? Seeing none, any objection to the question? Seeing none, we're voting. All those in favor of House Bill 2643 as amended, vote aye when the bell rings. Those opposed, vote no. As every member vote, as the amendment was changed, their vote. Mr. Clerk, please take the vote.
Ayes 86, 1 nay, 7 present, not voting.
House Bill 2643, having received a constitutional majority, I hereby declare passed. Without objection, most reconsider table. Next bill, Mr. Clerk.
Mr. Speaker, that brings the body to item 15 on that calendar. Item 15, House Bill 483 by Chairman Farmer, relative to District Attorneys General. Mr. Speaker, pursuant to Rule 49, there's been a 50-minute time limit set for this bill.
Chairman Farmer, you're recognized.
Thank you, Mr. Speaker. I move past this House Bill 483 on third and final consideration.
Chairman Farmer moves passes. Bobby second. Mr. Clerk, call it first amendment.
House Judiciary Committee Amendment number 1.
Chairman Russell, you're recognized. Oh, Vice Chairman Davis, you're recognized.
Thank you, Mr. Speaker. The amendment rewrites the bill. Move to adopt and defer to the sponsor for further explanation.
Vice Chairman Davis moves adoption of committee amendment number 1. Probably second. Any discussion on the amendment? Seeing none. All those in favor of committee amendment number 1 say aye. Aye. All those opposed say no. The ayes have it. You adopted. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Chairman Farmer, you're recognized.
Thank you, Mr. Speaker. Members, what this bill does, it creates two or three things. One, it creates an audit process to where we can keep up with the cases that the Memphis Safety Task Force came in and the president came in there in Memphis and cleaned up things and helped us get Memphis on the right track. Want people to be safe there and want them to visit and come and spend money and enjoy Tennessee. So this is going to allow us to give us a mechanism to keep up with those cases and the cases that are prosecuted there and the results of those cases. So number one, it creates an audit process there. Number two, it creates a mechanism to where we ensure that cases in Memphis, the 30th Judicial District only applies to that district. It ensures that those cases are when people are murdered, raped, kids are molested, things like that, all crimes that deserve to be prosecuted are prosecuted. If there's a situation where there's a crime that's not being prosecuted, our Attorney General can petition our Supreme Court to appoint a pro tem Attorney General to come in and look at that and prosecute those cases. So the whole intent and point of this bill is to be sure that Memphis continues on the path that Memphis is on, because Memphis is an absolutely beautiful place. I don't get over there enough because I'm from East Tennessee, but members, the time I've been there, I've enjoyed my time. And we want people that live there to be safe. We want the children that live there to be able to go home back and forth from school and not worry about being abducted. Members, we want people to visit Memphis because Memphis has been an economic driver of this state for many, many years. And we want it to continue to thrive. So I see this as a public safety bill. I see this as a victims' rights bill as well. So we want to keep Memphis on the right track. So members, Mr. Speaker, with that, I renew my motion and I would be happy to answer any questions that anyone may have.
Chairman Farmer renews his motion. Leader Camper, you're recognized.
Thank you, Mr. Speaker. Mr. Speaker, I yield 3 minutes to Chairman Clemens.
Chairman Clemens, you're recognized.
Thank you, Mr. Speaker. I also love the city of Memphis, and I also have a lot of respect for the district attorney being unfairly targeted with this law. This gentleman, I will just point out to some of you, and not only did I learn from him in law school, but one of the things that I observed from him was when the Federalist Society at the University of Memphis Law School didn't have a sponsor and couldn't have a chapter, the gentleman being targeted stepped up and sponsored the Federalist Society so that they could have a chapter at the University of Memphis. Now he's living rent-free in a state senator's head and generating legislation like this. Now, the very point of this legislation is to somehow second guess a district attorney. The Constitution of the state of Tennessee, Article 6, Section 5, already provides for the Supreme Court to do exactly what this bill seeks to allow our state's unchecked attorney general to do. Article 6, Section 5 states, in cases where the DA fails or refuses to attend and prosecute, according to the law, the court shall have power to appoint an attorney pro tempore. Now, for some reason, we're trying to give our unchecked attorney general the power to usurp that and instigate this type of thing, which our Supreme Court already has the power to do. Ladies and gentlemen, district attorneys in the state of Tennessee have broad discretion. Precedent is clear in the Supreme Court of this state. Dearborn versus the state, Ramsey versus Oliver Springs, both clearly establish that a district attorney's authority to prosecute offenses may not be impeded. It establishes clearly he or she is answerable to no superior and has virtually unbridled discretion in determining whether to prosecute and for what offense. And then the formulation of this decision, he or she is answerable to no one except for the Supreme Court, as is clearly stated in our Supreme Court. Dearborn versus State dates back to 1978. Other cases are more recent. The district attorney and the only district attorney can make the decision whether to proceed with a prosecution for an offense committed within his or her district. The Attorney General opined on this issue a few years ago. In 2001, one of our most respected state attorney generals answered the question, if the district attorney does not prosecute actions, does any other individual entity have authority to do so? Conclusively, no. District attorneys general are solely responsible for the prosecution of state criminal matters in their districts at the trial level. Accordingly, no other individual or entity has the authority to prosecute state criminal actions. Ladies and gentlemen, this matter is settled. The Supreme Court can do exactly what we're attempting to hand to our Attorney General for other purposes. Thank you, Mr. Speaker.
Leader Camper, you're recognized.
Thank you, Mr. Speaker. I yield 2 minutes to Representative Shaw.
Representative Shaw, you're recognized.
Thank you, Mr. Speaker. And to the sponsor, certainly many of your comments that you made is very true. Memphis is dear to me as well. I think the problem I'm having trying to see through all this is now that much has been done, it has put much more on the DA in Memphis to get done. So why are we punishing him rather than trying to send him some more help to get some things done? How do we single him out compared to other DAs across the state? If there's more crime solved, that means he's got more work to do. And what bothers me is, how does he get it done if we put more on him and then say we're going to punish you if you don't get these things done? Can you help me out with that?
Chairman Farmer.
Yeah, thank you, Mr. Speaker, and Representative Shaw. I appreciate the questions. You know, he ran for that office and he realized, and I would hope he'd understand the responsibility that he was taking on to take care of the 30th Judicial District in Shelby County. That's a huge area. So he's just going to have to continue to work hard and work harder, just like we do here. You know, what we do in three months, we could probably take a year to do it. But at the end of the day, he's just going to have to work harder. He signed up for the job. His folks trusted him to do that job. He was elected for the job. So he's just going to have to work harder and ensure that people continue to stay safe. We want Memphis to continue on the path that's going up.
Representative Shaw.
I appreciate those comments, but that's exactly what I'm talking about now. But you can only do so much as one person. I think we need to send him some help. We've sent him some help, and I think we need to send him more help to get those things done. So this just applies to Memphis only. Is it?
Chairman Farmer.
That's.
Leader Camper.
Thank you, Mr. Speaker. Mr. Speaker, I yield 2 minutes to Representative Pearson.
Representative Pearson, you're recognized.
Thank you. The constant barrage of legislation and attacks on our district attorney isn't making our community safer. The district attorney is an elected official. He was elected by the people of Shelby County to do the job. And at every turn, because of one particular senator's gripe and a desire for people to be tough on crime, even when statistics showed before the Memphis Unsafe Task Force was here that crime was going down, we have legislation like this. The continued usurpation of the work of local DAs, of school boards, of city councilors, county commissioners, is ultimately taking away from an ideal that was pushed with conservatism of local control and local government being able to know what is best for the people that they represent. Indeed, the workload for the DA has increased. Defense attorneys are working overtime in Memphis. Our jail population has exploded. The Memphis Unsafe Task Force, which primarily has been targeting immigrant folks and people of color through racial biases, is not helping. It's only hindering our community. And a lot of businesses that folks have thought were going to improve, a lot of them are struggling and are likely going to be closing down in the next few months because people aren't visiting our city in the ways that they used to. And instead of finding ways to deal with root causes of problem, which is poverty eradication, not military occupation, we get legislation like what you are presenting, which is not going to be helpful overall to the safety of our community. If you want to make us safer, then do something about increasing wages, expanding access to healthcare, making sure people have housing, deal with the gun violence epidemic. This is not addressing that, and so I won't support it.
Leader Camper.
Thank you, Mr. Speaker. Mr. Speaker, you have 3 minutes to Representative Powell.
Representative Powell, you're recognized.
Thank you, Mr. Speaker. So members, this is a really interesting, and we have committees for a reason. This was a very interesting discussion that we had in our committee. And I want to say that I was actually impressed with a lot of the arguments from members of the other side of the aisle who had concerns about this. And we heard really strong testimony from the DA's conference about the precedent that this would start and create. And, you know, let's think about this. In Tennessee, our Constitution, the writers of the Constitution were very deliberate when they decided the term of our district attorneys and public defenders. I don't know how many of you know this. I would assume everyone hopefully does, but DAs are elected to an 8-year term. And the reason that DAs are elected to 8-year terms is because we wanted our judiciary to be free from the bias of the swinging and shifting political winds of the day. So just because we have an executive in the White House who is targeting the city of Memphis and has targeted other cities, let's look at the disaster that happened in Minneapolis where they've had to back out now. We are seeing this task force really inserting themselves into Memphis. And what's happened is that this has caused multiple problems. And if we allow this bill to pass, we're going to be creating a unique situation where you have a pro tem who has the powers to audit anything that this task force handles. It creates 2 different levels within the DA's office. It puts every assistant DA on their heels, worried that anything that they decide on to prosecute or not prosecute is going to be audited. And it's a radical departure from where we've operated. We want to keep our DAs independent. That's why they're elected to 8 years. And the last thing I'll add is, this could also apply to any one of our DAs. Just because there's a task force in Memphis, there could be one set up in Nashville, and we could create this problem throughout the state. Thank you, Leader.
Leader Camper.
Thank you, Mr. Speaker. Mr. Speaker, I yield 4 minutes to Representative Salinas.
Representative Salinas.
Thank you, Mr. Speaker. In the Judiciary Committee, we had a very spirited debate where people from all walks of life, all the way from left to right, had the same concerns. Because regardless of where you are on the political spectrum, you voted. You voted for your DA. You voted for the public defenders. You voted for the judges. Those people are elected positions. The chairman just said he ran for that office. He was elected to that job. He just said that. So every community gets to elect what these departments look like. And what this bill does is it takes an elected position and puts control of our community's judicial decisions to an unelected AG. That is what's happening within this bill. And that person will be appointed by 5 members of the Supreme Court. So we're taking the decision of an entire community. You may not agree. No one's asking you to agree with what decisions are being made. I don't agree with some things that happen in East Tennessee or what the DA in your local community does. But I agree that you voted for them. I agree that the people of that judicial district elected them to be in that spot. And I would not try to overturn those decisions because I respect the process and I respect democracy. And what this bill does, it fundamentally changes the structure and the dynamics of a way that the DA's office looks like and how it looks at cases. Because people are not going to be looking at their cases of how they are going to be addressing it and how their voters ask them to address some of these issues. They're going to be saying, oh, this is going to come up in an audit. What is the political lens? What is the political lens that this will be interpreted under? That's what it's going to do, right? And we already have, I think my colleague from Davidson County said, we already have in code what happens if a DA refuses to prosecute. So we have TCA code 8-7-106 already establishes what when a DA refuses to prosecute. And I'm going to read a part of that. It says, if a district attorney general temporarily or categorically refuses to prosecute all instances of a criminal offense without regard to the facts, circumstances, then the attorney general and a reporter may petition the Supreme Court for the appointment of a district attorney general pro tem. This is already in code. So why are we singling out our judicial district because people don't agree with what the people elected for this district attorney, right? So this would overturn that. And if it's going to happen to Shelby County and District 30, it can happen in your district as well. Remember what they said about vouchers? That is Tennessee-wide now. So while this version singles out a district, it doesn't mean that it will always be the case. This puts a map for them to take this to other districts. So with that, I yield the balance of my time.
Leader Camper.
Thank you, Mr. Speaker. Mr. Speaker, I yield 3 minutes to Representative Miller.
Representative Miller, you recognize.
Thank you, Mr. Chairman. Mr. Speaker, this is somewhat personal. This bill, I know our DA, Mulroy. He's a personal friend. When he was appointed in September of 2022, the city of Memphis, state of Tennessee, there were 4 cases and I want to speak directly to my Republican colleagues. There were 4 cases that our DA was involved with, and it received not just national attention, but it received international attention. Those cases were, and I want to know how many of you all are familiar with the Elijah Fletcher case. How many? Of course, you've heard of that case. Tyree Nichols case, you've heard of that case. It received national attention. Then there was the case of a young Dolph, national rapper. And more personally, there was a case of Ezel Kelly. This young man did a shooting spree in Memphis. And I remember the night that I was out at a venue. I left home, got home, and found out that Kelly had actually shot an individual a couple of blocks from my home. When our DA was elected, all of these cases were thrown at him, and he worked those cases. He did well in those cases. He did well in those cases. Tremendous amount of pressure with this DA. This bill is about one thing. An individual over in the Senate has relentlessly, since he was elected, want to undermine him for whatever reason. It should be called the vendetta bill, the envy bill, the bullying bill, because that's exactly what this is about. And I say to my colleagues, do not allow this bill to pass because it's wrong. It's not the right thing to do. And I would hope that you would not vote for this bill. Thank you, Mr. Speaker.
Leader Camper.
Thank you, Mr. Speaker. Mr. Speaker, I yield 3 minutes to Representative Harris.
Representative Harris.
Thank you, Mr. Speaker. Sponsor, I'm going to read these 2 articles first, and then I'll ask my questions, if you don't mind. Article 11, Section 8 says that the legislature shall have no power to suspend any general law for the benefit of any particular individual, nor to pass any law for the benefit of individuals inconsistent with the general laws of the land, nor to pass any law granting to any individual or individuals rights, privileges, immunities, or exemptions other than such as may be by the same law extended to any member of the community who may be able to bring himself within the provisions of such law. Article 11, Section 9 says that any act of the General Assembly, private or local, in form or effect applicable to a particular county or municipality, either in its governmental or in proprietary capacity, shall be void and of no effect unless the act by its terms either require the approval of a 2/3 vote of the local legislative body of the municipalities or county, or requires approval in an election by the majority of those voting in said election in the municipality or county affected. Sponsor, does this legislation and audit have statewide application?
Chairman Farmer, you're recognized.
Okay, thank you. I apologize. I had to turn around there just for a moment. It does not have statewide application here. This is only for the 30th Judicial District. We're certainly within our purview, and we're constitutionally, we're in a safe posture to do so.
Representative Harris.
Thank you, Mr. Speaker. Sponsor, can you explain how we're in a safe posture to be able to do so constitutionally if it wasn't decided on by the local government or have statewide application?
Chairman Farmer.
Thank you, Mr. Speaker, and I appreciate the question, and I think that's a little beyond this bill in of itself. I'm happy to have that conversation with you. We can get with legal and talk about how that process works. But at the end of the day, think about this. Crime's been reduced by 50% in Memphis since the Memphis Safety Task Force went in. We've put in a lot of federal and state resources there. So all this bill attempts to do is to continue allow for Memphis to continue on that trajectory. Look, I know it's not an easy pill to swallow, but at the end of the day, we're on firm constitutional grounds to do so. And we just want to encourage, the 30th Judicial District. We wouldn't be in this situation if the district attorney in Memphis had been doing his job to begin with. He's behind. So there's catching up to do. The federal government and state governments will help him get there. He's caught up at this point in time. He probably had.
Leader Camper.
Thank you, Mr. Speaker. Mr. Speaker, I yield 4 minutes to Representative Towns.
Representative Towns.
Chairman, thank you very much. Representative Farmer, I've always thought you to be a strong guy, good stand-up kind of guy, a man that would follow his own direction as it relates to telling the truth. Now, I'm going to ask you a series of questions and make a few comments. Would you want this kind of action in your neck of the woods? What we're doing today to Memphis and Shelby County, would you want this to happen in your neck of the woods? Your Sevier County, would you want that to happen up there?
Chairman Farmer.
Thank you, Mr. Speaker. Yes, I would. If Sevier County's crime rate was half of what Memphis's was, I would expect the General Assembly to step in. I would expect the federal government to step in and clean Sevier County up. But fortunately, we're not in that situation. Fortunately, our district attorney prosecutes cases and puts people in jail when they rape, when they murder, when they commit aggravated assault, a DUI. Our streets are safe. And unfortunately, the district attorney in Memphis chose not to do so, chose to turn and look away and allow people to commit crimes over and over and over again, enough to where unfortunately, we lost lives. People were murdered and raped and beat up, and he just didn't do his job. That's what we're here for.
Representative Towns.
I need to reclaim my time.
No,
Okay.
Representative Towns, I will, no, sir. No, sir. If you ask a question, he gets to respond. You do not get to rush him through his response. If you do not want him to respond, do not ask him a question. Representative Towns.
Okay. The numbers in Sevierville is 40.35 per thousand. You got 98,000 people up there. You got a 600,000 or 700,000 in Memphis. When you look at those numbers, there needs to be something addressed in more than just Memphis and Shelby County. Now, I take issue with the fact that we're talking about Shelby County. We tried this with charter schools. It was unconstitutional then, had to weave some more people in to make it constitutional. There's always a target on Shelby County where most of the money outside of Nashville comes from. If you care about crime, you got to care about the economic conditions down there. I never hear this body talking about that. Enhancing the overall economic growth of that city. And you're going to brag about the money that you send back. You're sending our own money back to us. You're taking my money and sending it back to me. And then you're subsidizing the rest of the county. So the DA's General Conference bill, did the DAs oppose this bill?
Chairman Farmer.
Thank you, Mr. Speaker. Representative Towns, the Attorney General's Conference is neutral on this bill.
Representative Towns.
So the Attorney Generals are neutral on this bill. That's not the information that I have. It could be some conflicting stuff out there. I have that they oppose the bill, and I can see why. This bill, as it relates to the DA, should never be politicized. Any DA should not work at the whim of the state to do their bidding, or police officers to do their bidding. They should be independent enough to do what is right for the state and where its police officers are concerned. Do you not see this bill handcuffing, no pun intended, the DA, any DA, not just in Shelby County, any DA? Does this bill tie their hands?
Chairman Farmer.
Thank you, Mr. Speaker. Representative Towns, if this bill does anything, it encourages every DA elected in this state to do their job.
Representative Towns.
Well, I submit to you that they've been doing their job, not the way some people want it to be done. They have to do their job because the people down there are watching as well. Now, if there's a problem with some individual, have you ever talked to the DA yourself, sat down, had a conversation with this man?
Chairman Farmer. Oh, out of time. Sorry. Leader Camper, you're recognized.
Thank you, Mr. Speaker. Mr. Speaker, members, there was a time in this state. Oh, I guess I got to yield myself my time.
You want the remaining balance?
How much time I got, Mr.? Okay.
Minute 15.
I yield the remainder of the time
Yes, ma'am.
to Leader Camper.
Leader Camper, you're recognized.
Bye, George. There it is. Thank you, Mr. Speaker. Mr. Speaker, members. Look, I remember there was a time in this state where conservatives, both R and D, when I got here, R and D conservatives, truly believe from a constitutional perspective, local knows best. We trust local, closest to the people. Now it looks like as if, well, if we don't like those closest to the people, the way that they are deliberating, the way that they are governing themselves, we want to take their power. I think we're straying away from our own values, some of us. These are values that have been stood upon for years and decades in this chamber, but somehow we are moving away from that. You said it earlier. He ran, he won. Let him work.
All right. Leader Lambert, you are recognized.
Thank you, Mr. Speaker. And we have 25 minutes from my understanding, correct?
That's correct.
Well, Mr. Speaker, I'm like a stone going downhill. Once I get rolling, I'm probably going to take all of it. So on this particular piece of legislation.
So you're wanting all 25 minutes?
Absolutely, Mr.
All right.
Speaker.
Leader Lambert has 25 minutes.
Thank you, Mr. Speaker. And now that we've begun. So I don't think there's anybody in this room that doesn't realize that I used to be an assistant district attorney. Ray Whitley was the district attorney in Sumner County. The man served for over 50 years as a prosecutor. There is never a time in his entire time that he served that we would have ever had to pass a bill to look over his books, to ask whether or not the violent criminals in that community were being prosecuted, to wonder whether or not some violent rapist, murderer, or robber was getting probation, and that an assistant district attorney was looking at a victim of violent crime and saying, that person is more important than you. Because there's no victim in this state that has ever asked to be a victim. The defendant makes that choice. They make that choice to go out there and violate the laws that we pass. We put the statutes on the books. If you don't like the statutes that are out there that make it illegal to murder, rape, rob, burglar, and everything else, I know you don't like them, Justin. See you later. You don't like those laws. But we do, because it makes our community safe. And when some district attorney, any district attorney, says that they're not going to prosecute an entire section of the code, a bill like this is necessary. Because all of them, every single district attorney, has got to do that job. The job that Ray Whitley asked me to go to work every single day and do, and to put my arms around and to hold hands with the victims of violent crime. Their lives are shattered. There's nothing we can do in the court system to put them back together. But members, let's get real with this. In one particular district, there were 514 felony cases resolved in December of 2025. That's 1 month, okay? 144 of those cases were dismissed. Non prost, just dismissed outright. Of the 370 prosecuted cases, 178 received suspended sentences. That's just probation. That's no jail time. That's a smack on the wrist. 84 received some prison time. 63 received diversion. You know what that means? When they finish their sentence, it's gone like it never existed. Wiped off the face of the earth, forgiven, expunged. That's what diversion means. 45 are released on time served. You know what that means? They were in jail. The community was safe from these folks, and they were released on time served. Go forth and sin again. 75% of all defendants received no prison time whatsoever. 49% of the sentences imposed were less than 1 year. We can send all the troopers, we can send all the guardsmen, we can send all the funds, and we've sent hundreds of millions to any district in this state. If you do not have a quality district attorney that will fight for the people in every single district, the entire system falls apart. Chairman Farmer, we've been at this for a long time. Thank you for bringing this bill. I had a couple of statistics there to highlight, and I was kidding about taking my 25 minutes because it only took 5. 3 years ago, Memphis had more murders than any city in the country. 397 people died in that city. Those are Tennesseans. We all took an oath up here to both create laws and uphold the Constitution. And we do that so that people can live their lives safe and happy and free and prosperous. 397 of them were killed in the city of Memphis, Shelby County. The year after that, it was down to about 285. Last year, it was down to 160. We're making progress. Transparency is never a bad thing. That's the bulk of this bill. But if any district attorney in this state, and I love these folks, they do a phenomenal job. But if any one of them wants to take your responsibility away from you and say that they will not prosecute an entire section of the code that you worked so hard to put in, then they absolutely should face the scrutiny of this bill. And if they won't do their job, should be replaced. Nobody's accusing anybody of doing that right now, but we're taking a really good look under the hood to make sure. Chairman Farmer, thank you. And Mr. Speaker, we would yield the remaining time to whomever likes it, but nobody else is going to speak from our side.
All right. That does that. Chairman Farmer, you are recognized.
Thank you, Mr. Speaker. I renew my motion.
Chairman Farmer renews his motion. All right, we are on the board. We are done. All those in favor of House Bill 483 as amended, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Davis, aye. Mr. Clerk, please take the vote.
Aye, 71, 23 nays, 2 present, not voting.
House Bill 43, having received a constitutional majority, I hereby declare it passed without objection. The motion for consideration table. Call up next bill, Mr. Clerk.
Mr. Speaker, that brings the body back to item 55. Item 55, House Bill 2404 by Representative Scarborough, relative to medical cannabis commission. Mr. Speaker, Senate bill's on the desk.
Representative Scarborough, you're recognized.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 0550.
Representative Scarborough moves to substitute form Senate Bill 550, properly seconded without objection. So ordered. Representative Scarborough.
Thank you, Mr. Speaker. I move passage of Senate Bill 0550 on third and final consideration.
Representative Scarborough moves passage of Senate Bill 550 on third and final consideration, properly seconded. Mr. Clerk, call First Amendment.
House Health Committee Amendment number 1, same as Senate Amendment number 2.
Chairman Terry, you're recognized.
Thank you, Mr. Speaker. Move to withdraw.
Without objection, amendment number 1 withdrawn. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Representative Scarborough, you're recognized.
Senate Bill 0550 establishes that one of the persons appointed to the Medical Cannabis Commission by the Speaker of the Senate must be specialist in the area of substance abuse prevention. With that, I renew my motion.
Representative Scarborough renews his motion. Any discussion on the bill? Seeing none, any objection to the question? Seeing none, we're voting. All those in favor of Senate Bill 550, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, please take the vote.
Ayes 93, no nays.
Senate Bill 550, having received constitutional majority, I hereby declare it passed without objection. The motion for consideration table. Call up next bill, Mr. Clerk.
House Bill 2503 by Chairman Williams and others relative to health insurance.
Chairman Williams, you're recognized.
Thank you, Mr. Speaker. I move passage of House Bill 2503 on third and final consideration.
Chairman Williams moves passage. Following second to Mr. Clerk, call First Amendment.
House Insurance Committee Amendment number 1.
Chairman Kumar, you're recognized.
Thank you, Mr. Speaker. Move to adopt.
Chairman Kumar moves adoption of Committee Amendment number 1. Probably second. Any discussion on the amendment? Seeing none. All those in favor of Committee Amendment number 1 say aye. Aye. All those opposed say no. The ayes have it. You adopt. Next amendment, Mr. Clerk.
House Amendment 2 by Representative Jones Davis and Mr. Speaker, it was timely filed.
Representative Jones, you're recognized.
Thank you, Mr. Speaker. This bill, which is actually sponsored by Speaker Sexton, is about selling junk insurance if the ACA is repealed. And what my amendment does, it says that we cannot discriminate against people with pre-existing conditions if this does take place. If these junk insurance plans are sold, they cannot discriminate against people with pre-existing conditions. They cannot have medical underwriting against people with pre-existing conditions. And the reason is simple. You know, these junk insurance plans are low quality, non-ACA compliant health plans that are currently unlawful under federal law, and that often hide high costs and minimal coverage, such as excluding pre-existing conditions, maternity care, or certain prescriptions. Marketed as cheaper alternatives, they offer few consumer protections, often leading to large out-of-pocket bills. And so this bill that Speaker Sexton is bringing us with his stand-in, Representative Williams, is actually an anti-consumer protection bill. And so this is a very simple amendment. I know there's people here who have pre-existing conditions. You know someone with pre-existing conditions. I think it's something that we can get behind, again, across the aisle. It's something that you hear independents, Republicans, Democrats say is that one of the most important thing that the ACA did is it stopped discrimination against those with pre-existing conditions. So if you have diabetes, heart issues, cancer, these junk plans would be able to discriminate against you if this bill takes effect. And so I'm hopeful. I don't know if they're going to call the questions. We won't be able to ask questions, but I hope that Representative Williams will be able to respond to this if this amendment does not go through. How will we protect those, Representative Williams, with pre-existing conditions if your bill becomes law? How will we make sure that mothers who need maternity care are not discriminated against if this bill becomes law? Those with diabetes and health and heart issues, how will we not discriminate against them if this bill becomes law? And so again, this amendment is about ensuring, and I'm going to read it. It says that a health insurance entity offering a plan pursuant to this section may require an individual to meet eligibility requirements to enroll in the plan, provided that the health insurance entity shall not conduct medical underwriting for or discriminate on the basis of pre-existing condition of an individual for such a plan. And so it's a very simple amendment, and I hope that some of my colleagues on the other side of the aisle will not be afraid to question these things that we know are wrong. And we'll hope that the sponsor will respond to these if this amendment does not take place. And so thank you so much. And with that, I move for adoption of this amendment.
Proper motion, probably seconded on amendment number 2. Discussion. Chairman Williams, you're recognized.
Thank you, Mr. Speaker. The Obama administration failed to define what this is. We're just simply defining what this health insurance plan is in statute. So that, Mr. Speaker.
Got it. Representative McCalman, you're recognized.
Thank you, Mr. Speaker. Move previous question on the amendment and the bill.
Previous question been called. Is there objection? Seeing none, we're voting. All those in favor of amendment number 2, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, please take the vote.
Ayes 19, 76 nays.
Amendment number 2 failed. Next amendment, Mr. Clerk. Oh, he called it on both. My apologies. I did not hear that. All right. We're voting on the bill. All those in favor of House Bill 2503, vote aye when the bell rings. Those opposed, vote no. Has every member voted? Does anyone wish to change their vote? Mr. Clerk, please take the vote.
Ayes 74, 20 nays.
House Bill 2503 having received constitutional majority, I hereby declare it passed by objection. Most for consideration table. Call the next bill, Mr. Clerk.
House Bill 2206 by Representative Sherrill, relative to Department of Children's Services. Mr. Speaker, Senate bill's on the desk.
Representative Sherrill, you're recognized.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 2459.
Representative Sherrill moves to substitute and conform to Senate Bill 2459. Probably seconded without objection. So ordered. Representative Sherrill.
Thank you, Mr. Speaker. I move passage of Senate Bill 2459 on third and final consideration.
Representative Sherrill moves passage of Senate Bill 2459 on third and final consideration. Probably seconded. Mr. Clerk, call the first amendment.
House Judiciary Committee Amendment number 1, same as Senate Amendment number 1.
Chairman Farmer, you're recognized.
Thank you, Mr. Speaker. Move to withdraw.
Without objection, committee amendment number 1 withdrawn. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Representative Sherrill, you're recognized.
Thank you, Mr. Speaker. House Bill 2206 has amendment which provide DCS from requesting detailed information about the number of types of firearms or ammunition that a foster parent or prospective foster parent owns or demanding access to inspect those firearms or ammo. The bill does not prevent DCS from asking whether firearms or ammunition is present in the home or whether they are safely secured. This legislation comes to in response to multiple foster parents that have informed me that the state is implementing a new checklist for home visits requiring foster parents to provide a complete inventory of all firearms, including type and quality, and allows DCS workers to inspect for accuracy. While I am fully committed to keeping children safe, always a top priority, these requests far beyond what is reasonable. Asking whether firearms are safely stored is appropriate and necessary. However, requiring a detailed list or access is an unnecessary invasion of privacy for law-abiding foster parents. DCS was consulted on the language of this amendment and have deferred with the inclusion of this amendment. Keeping children safe is non-negotiable, but it's possible to do so without overstepping privacy boundaries for the responsibility of law-abiding citizens. This bill strikes the balance, and I renew my motion.
Representative Sherrill renews his motion. Discussion on the bill. Representative Todd.
Thank you, Mr. Speaker. I move previous question.
Previous question been called. There is objection. We're on the board. All those in favor of previous question vote aye when the bell rings. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Camper, no. Mr. Clerk, please take the vote.
Ayes 67, 24 nays.
Previous question prevails. We're voting. All those in favor of Senate Bill 2459 vote aye when the bell rings. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, please take the vote. Campers, no. Not yet.
Ayes 72, 23 nays.
Senate Bill 2459 having received a constitutional majority, I declare it passed without objection. Most reconsider table. Call the next bill, Mr. Clerk.
House Bill 1263 by Chairman Slater relative to children.
Chairman Slater, you're recognized.
Thank you, Mr. Speaker. I move passage of House Bill 1263 on third and final consideration.
Chairman Slater moves passage. Public Secretary, Mr. Clerk, call the First Amendment.
House Judiciary Committee Amendment number 1.
Chairman Farmer, you're recognized.
Thank you, Mr. Speaker. Move to withdraw.
Without objection, Committee Amendment number 1 withdrawn. Next amendment, Mr. Clerk.
House Judiciary Committee Amendment number 2.
Chairman Farmer, you're recognized.
Thank you, Mr. Speaker. Move to adopt.
Chairman Farmer moves adoption. Committee Amendment number 2. Properly seconded. Any discussion on the amendment? Seeing none. All those in favor of Committee Amendment number 2 say aye. Aye. All those opposed say no. The ayes have been adopted. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Chairman Slater, you're recognized.
Thank you, Mr. Speaker. House Bill 1263 provides the exclusive procedure for the voluntary surrender of parental rights for a surrendering parent who does not want to appear before a judge while preserving judicial oversight. With that, I renew my motion.
Chairman Slater renews his motion. Any discussion on the bill? Seeing none. Any objection to the question? Seeing none. All those in favor will be voting on House Bill 1263 as amended. Vote aye when the bell rings. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Mr. Clerk, please take the vote.
Ayes 96, no nays.
House Bill 1263 having received a constitutional majority, I hereby declare it passed without objection. Most reconsider table. Call the next bill, Mr. Clerk.
House Bill 1934 by Chairman Slater relative to Opportunity Public Charter Schools. Mr. Speaker, Senate bills on the desk.
Chairman Slater, you recognize.
Thank you, Mr. Speaker. I move to substitute and conform to Senate Bill 1931.
Chairman Slater moves substituting form in Senate Bill 1931. Probably seconded without objection. So ordered. Chairman Slater.
Thank you, Mr. Speaker. I move passage of Senate Bill 1931 on third and final consideration.
Chairman Slater moves passage of Senate Bill 1931 on third and final consideration. Probably seconded. Mr. Clerk, call First Amendment.
House Education Committee Amendment number 1 is similar to Senate Amendment number 1.
Chairman White, you're recognized.
Thank you, Mr. Speaker. Similar to the Senate amendment. Move to withdraw.
Without objection, Committee Amendment number 1 withdrawn. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Chairman Slater, you recognize.
Thank you, Mr. Speaker. This bill requires the Department of Education to annually collect and report specified data on the department's website regarding the performance of Opportunity Public Charter Schools. With that, I renew my motion.
Chairman Slater renews his motion. Any discussion on the bill? Representative Parkinson.
Thank you, Mr. Speaker. I just caught this term from the clerk saying that the Senate amendment was similar to the House amendment that was withdrawn. What's the difference between the Senate amendment that's making the bill versus the House amendment that was withdrawn that creates the similarity and not the exact same language?
Chairman Slater.
Thank you, Mr. Speaker. And to the best of my recollection, that had to do with the date. Didn't have to do with anything that would be substantive to the bill.
Representative Parkinson.
Check. Thank you, sir.
Representative McKenzie.
Thank you, Mr. Speaker. So this is a bill that's going to create the opportunity school districts for people to go back to get their degrees regardless of age. Is this before us?
Chairman Slater.
Thank you, Mr. Speaker. And no, this is not that bill. There is a bill that is going through that is as you described. What this bill does is just requires reporting for a bill that we passed in 2024, the Opportunity Charter Schools. And this just requires reporting for Opportunity Charter Schools, which was passed in 2024.
Representative McKenzie.
Thank you, and thank you for that clarification. I actually signed off on that piece of legislation. Can you discuss that piece of legislation and the result of that? Has it been successful? And what we want to do is to learn from that. Is that what this report's going to do, or have we set up any opportunity charter schools? And if we have, what's their status?
Chairman Slater.
Thank you, Mr. Speaker. And to date, there are no Opportunity Charter Schools that are currently online. My understanding is that there is one that is before the commission, the Charter Commission, for approval, but there are no that are online. This just gets us ready for when Opportunity Charter Schools are operating in the state.
Representative McKenzie. All right. Representative Powers.
Thank you, Mr. Speaker. I move previous question.
Previous question been called. Any objections? Seeing none, we're voting. All those in favor of Senate Bill 1931, vote aye when the bell rings. Those opposed, vote no. As every member voted, as any member wishes to change their vote, please let the journal reflect Representative Hardaway is excused. Mr. Clerk, please take the vote.
Ayes 83, 13 ayes.
Senate Bill 1931 has received a constitutional majority. I hereby declare it passed without objection. Most for consideration table. Call the next bill, Mr. Clerk.
House Bill 2398 by Representative Stinnett, relative to children. Mr. Speaker, Senate bill's on desk.
Representative Stinnett, you're recognized.
Thank you, Mr. Speaker. I move to substitute and conform to SB 2525.
Representative Stinnett moves to substitute and conform Senate Bill 2525, probably seconded without objection. So ordered. Representative Stinnett.
Thank you, Mr. Speaker. I move passage of 2525 on third and final consideration.
Representative Stinnett moves passage of Senate Bill 2525 on third and final consideration, probably seconded. Mr. Clerk, call First Amendment.
House Health Committee Amendment number 1, same as Senate Amendment number 1.
Chairman Terry, you're recognized.
Thank you, Mr. Speaker. I move to withdraw.
Without objection, Committee Amendment number 1 withdrawn. Next amendment, Mr. Clerk.
Mr. Speaker, no further amendments.
Representative Stinnett, you're recognized.
Thank you, Mr. Speaker. This bill has to do with child centers in the state of Tennessee, and you have to be 18 years of age to work in one of those units. And this only changes it from 18 to 16, so work-based students in high schools can participate. I'll renew my motion.
Representative Stinnett renews his motion. Representative Sparks, you're recognized.
Yeah, I just want to say I think this is brilliant, and it's thinking outside the box. And childcare is a huge issue affecting all of us. It's affecting my family with grandbabies. But I just want to give you some kudos for this and whoever else involved with this. Thank you, sir.
Representative Stinnett.
Thank you, Representative.
All right, any further discussion? Seeing none, any objections to the question? Seeing none, we're voting. All those in favor of Senate Bill 2525, vote aye when the bell rings. Those opposed, vote no. As every member voted and member wishes to change their vote. Mr. Clerk, please take the vote.
Ayes 94, no nays.
Senate Bill 2525, having received constitutional majority, I hereby declare passed by objection. Motion to reconsider is tabled. Leader Lamberth, for what purpose?
Thank you, Mr. Speaker. I move to take up today's message calendar.
Without objection. So ordered. Mr. Clerk, call it first message.
Senate Bill 254 by Chairman Doggett.
Chairman Doggett, at your desk.
Thank you, Mr. Chairman. I move we roll this to the next available message calendar.
Without objection, roll to the next message calendar. Next order, Mr. Clerk.
House Bill 754 by Chairman Faison, relative to healthcare. Mr. Speaker, on April 13, 2026, substituted House Bill 754 for Senate Bill 676, adopted amendments 2 and 4, and passed House Bill 754 as amended.
Chairman Faison, you recognize.
Thank you, Mr. Speaker. Move to concur with Senate amendment.
Chairman Faison, 2 and 4. You concur with amendment 2 and 4. Very good. Chairman Faison moves to concur in Senate amendments number 2 and 4. Party Secretary, any discussion on the amendments? Leader Camper.
Thank you, Mr. Speaker. Representative, will you explain those two amendments that you're concurring in?
Chairman Faison.
Thank you, Mr. Speaker. Thank you, Leader Camper. They're tightening up the language for de-identified data.
Leader Camper.
Based on the last time we saw this particular bill, could you give us a little bit more of the substance of the bill so we'll know what we're tightening up?
Chairman Faison.
Thank you, Mr. Speaker. There was a provision that would allow the county and the data that was collected to be part of what was publicly made available, and they took that out. There won't be any county language. It'll just be in the state of Tennessee now.
Leader Camper.
Thank you, Mr. Speaker. So only the state would be gathering, collecting data. And does this amendment change what would happen with the data, who would see the data, whether data will be filed or cataloged or stored, or what would happen with the data?
Chairman Faison.
Thank you, Mr. Speaker. It's going to be treated the same way that all health data is treated.
Leader Camper.
This bill, and I'm not trying to confuse it, so that's why I'm just looking back at it. Is this the bill that deals with insuring people who have had gender affirming care, that they have to have 2 separate insurance policies to, should they decide to do this, or that they insure it on the front end, and then if they decide to have a reversal of the gender affirming care, then they'd have to have insurance on the back end as well. Is that the same bill that we're dealing with?
Chairman Faison, you recognize.
Yes, ma'am.
Leader Camper.
And so in that, the data that I'm just unclear about the data part of the bill. I understand the insurance part. Are you saying that the data will be collected on who have the insurance, who use the insurance? How is it? Can you tell me? I'm unsure about how the data is connected to this.
Chairman Faison.
Thank you, Mr. Speaker. It's going to be collected the same way that all medical data is collected. No matter if you go and have an ingrown toenail at a clinic fixed, or if you have surgery, or if you have anything done, data's collected, and we keep that data and stored, and it's available to the public. What we made sure with this amendment is that it's true in line with all HIPAA standards for de-identified data. So you would never, by looking at it, whatever process took place at the healthcare facility, you would never be able to say that happened to this person.
Leader Camper. All right. Representative Parkinson.
Thank you, Mr. Speaker. And to the sponsor, you're still the chairman of the Transgender Remorse Caucus, huh? What is this amendment from the Senate doing?
Chairman Faison.
I just told y'all. Speaking to her, bro. Pay attention.
Representative Parkinson.
Thank you, Mr. Speaker. It's unfortunate, but the noise level raises when you start speaking, so I couldn't hear you.
Chairman Faison.
Thank you, Mr. Speaker. To the gentleman from Shelby County, this amendment takes out the county that was identified originally where a person had care.
Representative Parkinson.
Thank you, Mr. Speaker. I'm just going to repeat what I think I heard. You said it takes out the county where the person had hair. I'm sorry, I couldn't understand what you were saying. Seriously.
Chairman Faison.
Thank you, Mr. Speaker. Care, C-A-R-E, care.
Representative Parkinson.
Thank you, Mr. Speaker. So it takes out the county where the person had care. So therefore, just making it kind of bland across the board with the data versus the county, because the county could have possibly identified someone, correct? Or helped to identify someone.
Chairman Faison.
Thank you, Mr. Speaker. I don't think the county would have helped anybody identify anybody, anyone identify anybody, but this strengthens that up to make sure that it's never an issue.
Representative Parkinson.
Thank you, Mr. Speaker. I remember when I was growing up in Port Arthur, Texas, well, when I was in high school in Port Arthur, Texas, there was one transgender person in Port Arthur, Texas, in Jefferson County that we all knew of, right? And so if that county would have been kept in, Jefferson County, if this bill was the law back then and Jefferson County would have been kept in, we would have known who that one person was. I suspect that Tennessee has small counties like that may have one person or two people that can be identified as possibly transgender in that county. And then if those counties would have been kept in, everybody would have known who that person was. So I'm glad that they've taken that out. I still think this is a horrible bill. I don't know why you felt the need to take the responsibility of leading transgender remorse. I still, for the life of me, don't get that. But I'm glad they've taken the counties out of it. I'm still not going to vote for your bill, but I'm glad they've taken the counties out of it. Thank you.
Deputy Speaker Zachary, you recognize.
Thank you, Mr. Speaker. My previous question.
Previous question been called. Is there objection? There's objection. We're on the board. All those in favor of previous question, vote aye. Those opposed, vote no. As every member voted, does any member wish to change their vote? Mr. Clerk, please take the vote.
Aye, 70, 21 days.
Previous question prevails. We're voting. All those in favor of Senate Amendments number 2 and 4, vote aye when the bell rings. Those opposed, vote no. As every member voted, does any member wish to change their vote? Mr. Clerk, please take the vote.
Aye, 73, 23 nays, one present, not voting.
Senate Amendment numbers 2 and 4 having received a constitutional majority, I hereby declare concurred in without objection. The motion to reconsider is tabled. Call up next message, Mr. Calendar. Mr. Clerk.
House Bill 1484 by Representative Gillespie relative to criminal offenses. Mr. Speaker, on April 9, 2026, the Senate substituted House Bill 1484 for Senate Bill 1467, adopted Amendment 1, and passed House Bill 1484 as amended.
Representative Gillespie, you're recognized.
Thank you, Mr. Speaker. I hate to do this, but I am moved to non-concur with Senate Amendment number 1.
Without objection, we non-concur. Next message, Mr. Clerk.
Senate Bill 1681 by Representative Love relative to hospitals and healthcare facilities. Mr. Speaker, on April 13, 2026, the Senate refused to recede from its non-concurrence in House Amendment 1 and appointed a conference committee.
Representative Love, you're recognized.
Thank you, Mr. Speaker. I move to accede to the request of the Senate and ask that a conference committee be appointed to confer with a like committee from the Senate to resolve the differences between the two bodies.
Representative Love moves to accede to the request of the Senate, asks that a conference committee be appointed to confer with a like committee from the Senate to resolve the differences between the two bodies. Properly seconded, so be it. Without objection, motion carries. I appoint the following members: Representative Hilton Haynes, Representative Gant, Representative Freeman, Representative Love, and Representative Love will serve as the chair. Next message, Mr. Clerk.
House Bill 1857 by Chairman Rudd relative to education curriculum. Mr. Speaker, on April 13, 2026, the Senate refused to receive from its action and adopting Senate Amendment number 1.
Chairman Rudd, you're recognized.
Thank you, Mr. Speaker. I move to refuse to recede from our actions concerning non-concurring in Senate Amendment 1, and that a conference committee be appointed to confer with like committee from the Senate to resolve differences between the two bodies.
Chairman Rudd moves to refuse to receive from our action and non-concurring in Senate Amendment number 1, and that a conference committee be appointed to confer with a like committee from the Senate to resolve differences between the two bodies. Properly seconded. Without objection, motion carries. I appoint the following members: Representative Miller, Representative Doggett, Representative Davis, Representative Rudd, and Representative Rudd will serve as the chair. Next message, Mr. Clerk.
Senate Bill 2320 by Speaker Pro Tem Marsh relative to campaigns and campaign finance. Mr. Speaker, on April 13, 2026, the Senate refused to receive from its non-concurrence in House Amendment 1 and appointed a conference committee.
Speaker Pro Tem Marsh, you're recognized.
Thank you, Mr. Speaker. I move to accede to the request of the Senate and ask that a conference committee be appointed to confer with a committee from the Senate to resolve the differences between the two bodies.
Speaker Pro Tem Marsh moves to accede to the request of the Senate and ask that a conference committee be appointed to confer with the like committee from the Senate to resolve the differences between the two bodies. Properly seconded. Without objection, motion carries. I appoint the following members: Representative Parkinson, Representative Hicks of Washington, Representative Wright. Speaker Pro Tem Marsh. Speaker Pro Tem Marsh will serve as the chair. Next message, Mr. Clerk.
House Bill 2649 by Chairman Crawford relative to Bristol. Mr. Speaker, on April 13, 2026, the Senate substituted House Bill 2649 for Senate Bill 2711 and adopted Amendment 1, passed House Bill 2649 as amended.
Chairman Crawford, you're recognized.
Thank you, Mr. Speaker. What this is a simple charter change for Bristol, Tennessee in my district. And basically it's clarifying the differences in dates and also in the responsibilities between the school board and the city council. I stand for renew my motion.
Chairman Crawford moves to concur in Senate Amendment number 1, properly seconded. Any discussion on the amendment? Seeing none, any objections to the question? Seeing none, all those in favor of Senate Amendment number 1 vote aye when the bell rings. Those opposed vote no. As every member voted, does any member wish to change their vote? Mr. Clerk, please take the vote.
Ayes 96, no nays.
Senate Amendment number 1 having received a constitutional majority, I hereby declare concurred in without objection. The motion to reconsider is tabled. Next message, Mr. Clerk.
Mr. Speaker, that completes today's message calendar.
Thank you, Mr. Clerk. Leader. Leader Lambert, you're recognized.
Thank you, Mr. Member. Thank you, Mr. Speaker. Members, in a few moments, we will be adjourning today's floor session. The clerk will be describing to you what the rest of the day looks like. I would encourage you, if you have any piece of legislation or if you're on just about any committee, to pay very close attention to what the clerk says. There's a lot of work left to do today. It just won't be on the floor, but it sets us up for the next week or so to be able to adjourn at some juncture. So with that, I move that we resume today's calendar tomorrow and all remaining calendars.
Without objection, so ordered. Next order, Mr. Clerk.
Unfinished business.
Unfinished business. Leader Lambert, you're recognized.
Thank you, Mr. Speaker. After consulting with the Minority Leader and Chairman, I move that House Bills 2666 and 2668 be heard in the Private Acts Committee today. Mr. Speaker, I move that House Bills 2,666 and 2,668 be heard in the Private Acts Committee today.
67, 2006, 67.
Mr. Speaker, on what I got from the clerk, it said 2,667 and 2,668.
Yeah, that's right.
Okay,
That's right.
that's my motion.
All right. You've heard the motion. Any objections? Without objection, so ordered.
All right, Mr. Speaker, we're all going to struggle through this together. I move that House Bill 753 be heard in the Cities and Counties Subcommittee this week.
I just think members wanted to hear 6, 7, but nobody reacted to it. So, I mean,
Okay, we get it.
like, I don't know how many times you got to do something, but I mean, come on. You've heard the motion. Any objections? Without objection, so ordered. Leader Lambert, you're recognized.
Thank you, Speaker. You got me. But all right. Mr. Speaker, I move that the rules be suspended for immediate introduction and consideration of House Resolution number 196.
Mr. Clerk, please read the caption.
House Resolution 196 by Leader Lambert, the resolution to approve annual events by certain 501c organizations in accordance with the provisions of Article 11, Section 5 of the Constitution of Tennessee pursuant to the Tennessee Nonprofit Gaming Law.
You've heard the caption. Any objections? Without objection, the rules are suspended. Leader Lambert.
Thank you, Mr. Speaker. Members, there are 4 pages if you care to know which of the organizations we got in late, but we got them all in, and these folks will be able to do their raffles or events. With that, I move adoption of House Resolution number 196.
Leader Lambert moves adoption of House Resolution 196. Probably seconded. Any objection to the question? Seeing none. All those in favor of House Resolution 196, vote aye when the bell rings. Those opposed, vote no. As every member voted, does any member wish to change their vote? Mr. Clerk, please take the vote.
Ayes 91, no nays, 3 present. I voted.
House Resolution 196 having received a vote in the affirmative by 2/3 majority of the members elected to the 114th General Assembly, I hereby declare it adopted. Without objection, the motion reads here is tabled.
Who is this? Is that Rudd? Okay.
Chairman Rudd, you're recognized.
Thank you, Mr. Speaker. After consulting with both leaders, I move that the rules be suspended and for immediate introduction and consideration of HGR 1438.
Mr. Clerk, please read the caption.
House Joint Resolution 1438 by Chairman Rudd, a resolution to honor and commend the members of the 196th Field Artillery Brigade Embedded Training Team for their distinguished service in Afghanistan from July 2005 through July 2006.
You've heard the caption. Any objections? Without objection, the rules are suspended. Chairman Rudd, you're recognized.
I move adoption of HJR number 1438.
Chairman Rudd moves adoption of House Joint Resolution 1438. Probably seconded. Any objection to the question? Seeing none, all those in favor of House Joint Resolution 1438 say aye. Aye. All those opposed say no. The ayes have it. I declare it adopted. Without objection, most reads here is tabled. Chairman Hicks, you're recognized.
Thank you, Mr. Speaker, and members, bear with me while I read these bill numbers off. I move that House Bills 29, 519, 684, 886, 920, 1268, 1443, 1450, 2359, 1464, 1516, 1522, 1525, 1536, 1553, 1632, 1634, 1668, 1677, 1706, 1710, 1720, 1733, 1739, 1764, 1844, 1847, 1899, 1906, 1914, 1916, 1922, 1951, 1959, 1967, 2026, 2079, 2081, 2085, 2106, 2111, 2121, 2140, 2145, 2156, 2157, 2177, 2207, 2219, 2253, 2260, 2263, 2270, 2281, 2301, 2309, 2328, 2381, 2385, 2402, 2409, 2422, 2425, 2446, 2466, 2491, 2509, 2518, 2541, 2552, 2612 be placed on a Finance, Ways and Means Subcommittee consent calendar today, and if favorably considered, be placed on a Finance, Ways and Means Committee consent calendar today.
You've heard the motion. Any objection? Without objection, so ordered. Oh. Next order, Mr. Clerk.
Scheduling and procedural announcements.
Mr. Clerk.
Mr. Speaker, the schedule for today is as follows. Immediately following session, Finance Sub will convene in House Hearing Room 1 to take up the appropriations calendar. Immediately following Finance Sub, Finance Full will take up appropriations with Calendar and Rules meeting immediately following that. That is all in Room 1. After Calendar and Rules, cities and counties will meet in Room 1. Private acts will meet in Room 2. That's immediately following Calendar and Rules. Immediately following cities and counties, departments and agencies, then state and local, then government operations, then Finance Sub, then Finance, then Calendar and Rules, all immediately following each other in House Hearing Room 1.
All right, next order, Mr. Clerk.
Roll call.
Roll call. Mr. Clerk, please take the roll.
Mr. Speaker, 95 members present.
Next order, Mr. Clerk.
That completes the regular order, Mr. Speaker.
Mayor Cochran, you recognize.
Thank you, Mr. Speaker. I move the House stand in recess until 9 a.m. on Thursday, April 16th, 2026.
Without objection, the House stands recessed till 9 a.m. on Thursday, April 16th, 2026.